With me today is my dear colleague, today's presenter, Mr. Li Zhenzhang. Mr. Li is quite an experienced patent attorney and a technical broker. His practicing areas include bio-related patent prosecution, patent search and analysis, IP portfolio management, as well as IP strategy consulting. Mr. Li obtained his bachelor's degree in biochemistry and molecular biology and his master's degree in economic law, IP law direction. He also had wealthy experience in private sectors, domestic government departments, and international organizations before joining us, SPTL. Today, he'll share with us some most recent updates and practical advices on the bio and pharma IP policies. More precisely, what's going on in preparation and practice of PTA, PTE, and patent linkage in China after the most recent amendments to the patent law last year. The presentation will last for around 40 minutes. Questions are welcome anytime during the presentation. You may type in your questions and send them to us. All participants are muted. We'll have a session for question and answer after the presentation. Get back to you with the answers and to answer questions in live. Now, I'll hand over to Mr. Li. Hi, Zhenzhang, over to you.
All right, so I would say thank you, Ms. Yu, for your introduction. I would say good morning, good afternoon, and even good evening for some folks that have just logged in. Thank you for joining our webinar today. I am Li Zhenzhang, patent attorney at Shanghai Patent and Trademark Law Office. For today's webinar, as Ms. Yu just said, we will be focused on some updates and practical advice regarding the China Biopharma, or I would say biotechnology IP policies. So I would say for today's webinar, it will contain 3 sections. I will be introduce the patent term adjustment, aka PTA, patent term extension, aka PTE, and patent linkage based on current effective Chinese patent law. So before we get into the real business, let's first take a quick look at the current legislation statute. As you may know, the amended Chinese patent law was approved and effective as of June 1st, 2021. But until today, the implementing regulation and examination deadline are not finalized yet. Actually, the CNIPA, we always call it like the China National Intellectual Property Administration, did publish draft amendments for public review last year. So we expect they will be approved soon, possibly in the coming year, like in the coming months of this year. So as shown in the slide, on May 24, 2021, China published the interim rules for the implementation of the patent law, which provide us some guidelines for the amended Chinese patent law. Since we are here talking about the Biopharma IP policies, so I would say another organization as shown in the slides, National Medical Product Administration, aka NMPA, will also be rapidly mentioned during our presentation. So this organization is responsible for the marketing approval of drug in China based on the drug registration regulation and related guidelines. Okay, so without further ado, let's get into the real business, also the first section, PTA in China. So I would say to begin with, we also have to take a look at the current legislation statute. So specifically, Article 42.2 of the Chinese patent law established the PTA system for patent here in China. As we mentioned before, right now, besides the Chinese patent law, only the CNIPA's interim rule is effective. So wherein it conforms following key points. The first one I will be mentioned is PTA request shall be filed in paper format within 3 months after the patent is issued. Then second, PTA does not apply to patent issued before June 1st, 2021, and only invention patents are eligible. And the last one, I will be say everybody will be so interesting about like the office fee and the examination. then we will say a current stage in one word. So it will be decided later. Okay, then let's say since the Article 42.2 introduced the PTA system for China. So we believe for all the patentees, the most important question is the eligibility requirement. Then for this, I would say based on the current Chinese patent law and the interim rules, the eligibility requirements, actually you could say it includes three parts. So the first part is like the type of patent should be invention patent, and therefore the utility model and design patent are not eligible. And then second, the patent shall be issued on or after June 1st, 2021. So I would say most of the patent, if you have been granted recently, you can apply for the PTA. And then the last one, the patent is granted 4 years after application date and 3 years after the request for substantive examination. Okay, so then we come to the next, I would say, critical question. So with regard to the PTA provision, we believe, I would say, another important point is how to interpret I would say two very important terms. The first one is what we call unreasonable delays during the prosecution by the CNIPA. And another one is delays caused by the applicants. So based on the draft implementing regulation and the examination guidelines, the unreasonable delay during prosecution by the CNIPA is interpreted as any delay beyond 4 years after application date and 3 years after request for substantive examination in granting the patent. And then we come to the delays caused by the applicant. So right now, according to the draft implementing regulation and the examination guidelines, actions shown, as you can see in the slide, would be considered as the delays caused by the applicant. So wherein we think at current stage, the most important one is failure to respond to a CNIPA official notice within the specific time period. So here we must talk about like the official notice. So I would say, please be noted that the office notice includes not only the office action, but also like all the notification with a specific response time. Okay, so further, I would say another important or crucial question is how the compensation term is calculated, like how to calculate the PTA term. So based on the draft examination guidelines, PTA is calculated as the unreasonable delay by the CNIPA subtracted by the applicant. So wherein the unreasonable delays means the issue date subtracted the date of filing plus 4 years, and or the date of requesting for substantive examination plus 3 years. So I would say we believe CNIPA tend to later date for calculating the PTA. So you can say they have 2 dates. One is the issue, one is the plus 4 year, and another one is plus 3 years. So maybe they will be just using the later one. So we need to wait for the effective examination guideline. Okay, so here we also had to highlight some important timings. So actually, I think most of the participant here today is you are from outside of China. So you are using the PCT system to filing the Chinese application. So I would say for PCT CN national stage applicant, the date of filing is the date entering the CN national stage instead of the international filing date. And the date of requesting for substantive examination is the mailing date of the notice of entering the examination. So it's a little bit maybe you cannot get that much PTA terms. Okay, so Right now, we have to say many details regarding the implementation of the provision are still to be confirmed by CNIPA, but we still strongly encourage all the patentees to consider making PTA requests for all eligible patents. Unlike PTA in the US, wherein the PTA is automatically given by the USPTO, here in China, a patentee must make a PTA request. Then the CNIPA will start the internal procedure to decide how long it will give to the patent. Meantime, another two practical advice based on our local practice as shown in the slide. So I will say first, do not forget the deadline to submit the PTA request. It's 3 months. So please be remember that. Second, please avoiding delays caused by the applicants. So as we said before, at current stage, the most is in responding all office action in time. Okay, so all right, let's get into the second section. Actually, it's the PTE section. So again, let's take a look at the current legislation statute. Article 42.3 of the Chinese patent law established the PTE system for drug patent here in China. Similar to PTA, besides the Chinese patent law, only CNIPA's interim rule is effective right now, and wherein it conforms like the first one, PTE request shall be filed in paper format within 3 months from the date of approval of the new drug marketing authorization. Actually, failing to meet this deadline will have the risk losing the opportunity to seek PTE in the future. Second, regarding the retroactivity, according to CNIPA, PTE does not apply to drug approved on or before May 31, 2021, which means that only drug approved on or after June 1st, 2021 may be eligible. And the last one, like we just said, for the official fee and for the examination, same as PTA. Let's do it later. Okay, so as the PTE provision, like shown in the last slides, in order to compensate the time for new drug marketing, PTE is available for invention patent related to the new drug for which marketing approval is obtained in China. Same as PTA, many details and like requirements are still not very clear, which need to be explained and specified by the amended implementing regulation and the examination guideline. While I would say based on the draft, like based on all those drafts are available for public review, PTE is available to product patents, manufacturing method patent, and medical use patents directed to new chemical drugs, biological drugs, or traditional Chinese medicine for which marketing approval is obtained in China. Okay, so then let's get into another slide. This slide we will talk about like how to interpret the word new drug. What type of drugs are eligible? We think it's another important question we need to discuss here. So based on the draft guideline, actually the examination guideline, it contains that the PTE is available for patents of innovative new drug and certain improved new drug as defined in the drug registration regulation and related guideline issued by the NMPA of China. So accordingly, I would say the innovative new drug here refer to the drugs that are new to the world and have not been approved, or I would say marketed outside China. So specifically here, what the innovative new drug includes is the class 1 of chemical drugs and the class 1 of prohylated biologics and the class 1 of the therapeutic biologics. So then I would say, as for, you may ask, what the certain improved new drug? So based on the draft examination guideline and the NMPA's regulation. So in total, there are 5 classes. So I will be already put them in the slide. So those 5 classes, they are eligible for requesting PTE. But so here I will say, right now, based on the current available draft, that the drug that have been approved and marketed outside of China at the time of filing this new drug application are not eligible. So in a word, I would say in summary, right now, it will say the imported drug are not eligible for PTE. So at current stage, we do not know if such classification and such interpretation will be included in the effective regulation or guideline. If so, if you choosing class 3, like the imported drug at the time of filing this NDA in China, you maybe have the possibility you will be losing the opportunity to request a PTE for the related patent. So I think this is really important. And if they have some update, we will be definitely telling our clients. Okay, so we made a summary and we will say, so based on current available regulation or guideline, and it also includes some of the experience we have, because we just filed like 2 or 3 the PTE application, the PTE request to the same IPA. So we summarize the other specific eligibility requirements you should be or I would say you should be aware. So there are several, but I would say I just mentioned like some of the really important one. So the most important one, I think, like the issue date of the patent shall be early than the approval date of the drug. And the second one is like right now, according to the draft, they were saying like the remaining protection term of the patent shall be more than 6 months. And then it's also very important, the patent has not been granted a PTE yet. And then another one, the technical solution related to the approved drug shall fall within the protection scope of the claim of the patent. And also it's a little bit like related to like how many PTE, how many compensation term you can get. So according to the draft regulation, if multiple patents are related to one drug, PTE can only be requested for one patent. And then if a patent covers multiple drugs, then the term of the patent can only be extended under PTE for one drug. So that's basically what we have for the eligibility requirement. Then we come to how to calculate the PTE. So according to the draft implementing regulation, PTE will equal the period which elapsed between the application date of the patent and the date of the first marketing authorization of the drug in China, reduced by a period of 5 years. So they also have some other requirements. I will be saying like, in total, the PTE shall not exceed 5 years, and the resulting total effective patent terms shall not exceed like 40 years from the approval for marketing of the new drug. So another important thing, according to the draft guidelines, like if the patentee has requested both PTA and PTE for a patent, the CNIPA will first like determine the PTA, and then they will become to the PTE. But normally it will take like the 3 months time limit for requesting the PTA. And later, let's come to take a look at the protection scope. So it's not like you can protect all your claims in the patent you are requesting for PTE. So as for the protection scope doing PTE, according to the draft regulation, The PT, it says like the draft deadline defines that the patent doing PTE is limited to the new drug for the indication as approved by NMPA of China. Okay, so basically we just have a brief introduction of the PTE system here in China. So let's come to this really, I would say, practical advice based on our local experience. So I would say first we will be suggest all of our clients and all of the participants today, considering like the submitting PTE request for all related patents. Right now, I would say, although the eligibility requirements or other limitations to the PTE request are not settled down, but you could decide after the implementing regulation and the examination guidelines are finalized, or maybe like the same IPA issue any notification, so you can correct, or maybe you can decide later. But right now, if I would say, because right now, if you lose this kind of opportunity, you don't have any chance to seek PTE to have this kind of time for your patent terms. So that's why we say the second practical advice is like, do not forget the deadline. So the deadline is within 3 months from the date of approval of the new drug. And failure to file the PTE request will lose the opportunity to obtain the extension. Okay, so last one, you can say we have, the last one is have 1, 2, 3, 4, that's so many requirements. So it's the formality requirements. As you can say on the, I will be, maybe for you guys, it should be the left side or anyway. So you can, I have like some picture on the, in the slides. So it's kind of showing you the formality requirements. So based on saying based on right now, I would say based on CNIPA, you have to prepare a lot of documents so you can request for the PTE. So we're in, I would say, all those stuff, all those documents. The most important one is you need to fill in one of the forms showing in the slide. So as you can see, within the slide, you need to provide a lot of information related to the drug. For example, you need to provide the name, the name of the drug and the drug registration certificate. You also need to prepare a consent letter, like showing like the marketing association holder is authorizing the patentee to request a PTE. Also, you need to have the material showing that the drug manufacturing process approved by NMPA. And later, you also have to make a remarks like stating like the drug and the indication approved. And also you need to like specify like the related claims. You also need to explaining why the technical solution involved in the drug falls under the protection of the sale of the patent. Also, you also need to like say like the basis for the PTE calculation. You also need to like make yourself like you also need to explain like the protection scope doing the PTE. Okay, so right now it's a formality requirement we found in those kind of PTE request form, but CNIPA did not publish any, I would say, so how to say, they did not say like you need to prepare all those documents. So right now what they do is just, you can file the request, but we do not exam, we will be waiting for the amended examination guideline and all those documents are effective. Okay, so let me take a really small break. I will be having some water. So there will be come to the part 3. patent linkage. So I think everyone, sometimes people will also call it like the early resolution mechanism for drug patent dispute. So again, we need to have like taking a look at the current legislation statute. So Article 76 of the Chinese patent law established the patent linkage system here in China because it's really long provision. So instead of putting all the text of the provision, I just summarize the key point of this article. So there, in total, I will be saying they have 4 key points. The first one, it says like they will be establishing a platform to register patent information for marketed drugs. So here you may be, I will be saying it a little bit like similar to the US, like a little bit like the FDA, like the US FDA's Orange Book. And I will be saying about that later. And second, it requests like generics to submit 4 types of patent certification for like if they are trying to seeking the market approval. And also we will be explaining that later in our slide. And then the third is like establishing like a mechanism for drug patent dispute. So here we'll be seeing like there will be 5 days for the patentees to file an opposition to Beijing IP court or like CNIPA. So it's really interesting. And this, if the patentees file this kind of lawsuit or like this like complaint to CNIPA, it will also initiate it like a 9-month stay period for the generic drug. And the last one, like 12 months market exclusivity if for the successful patent challenge. So it will be a little, I would say, it would really have for the generics, it will be a huge benefit. So right now, I call it's the same because the implementing regulation and the examination guideline are not finalized. But CNIPA, NMPA, and Supreme Court publish or issue lots of, I would say, official interpretation or like related documents to say like how this patent linkage system will be implemented, like how this patent linkage system will be effective in China. So I think most of you guys here today are familiar with the US Hatch-Waxman Act. Lots of people always ask us like, is this patent linkage system in China is like a Chinese version of the US Hatch-Waxman Act? So here I must admit, so the patent linkage system here in China is I would say a Chinese version of the Hatch-Waxman Act, but with lots of Chinese characteristics. So I will be showing you in the next slide, like why I will say they have some difference. So comparing with the US system, as you can see in the slides, the opposition for patent certificate of the generic could be filed, I would say in China, you could be filed to the court, actually it's Beijing IP court, or you can also file it to the CNIPA. Instead of like the US, you can only file it with the federal court. So second, the stay period in China is 9 months instead of 3 months in the US. And then the last one, as you can see, the market exclusivity is 12 months, but comparing with the USA, it's only like 118 days. So for me, I would say it will be a huge benefit for the generics manufacturers. Okay, so as we mentioned before, the patent law say like there will be a registration platform for patent linkage system. So the website for this platform is shown in the slide. So in order to, I would say, in order to provide you guys more practical information, let's say what the branded drug manufacturer and the generic drug manufacturer could, or like what they should do in the platform. So I would say, let's say, first I would say for the branded drug manufacturer. So if you are the MA holder of a chemical drug, like biological preparation or traditional Chinese medicine, then you can, or I would say you should register relevant patent information in the platform within 3 days of receiving the drug registration certificate. And similar, I would say at the same time, you also should update your registration if you have any like update within 13 days of any change. So I would say right here, I must say the MA holder must register a lot of important information. For example, you need to register the drug name, dosage form, and specification. You also need to have the patent, like the patent information. For example, like the name, the patent number, the patent E, or maybe like the relationship between the drug and the patent. You also have to have the contact person information, and like so that then let's say what happened or what the generic drug manufacturer should do. Sorry, I just mean like the second part. So you just register it. Then what you should do is like you also should monitor the platform regular. So in order to, as that way, you can know the registration information filed by the generic, like generics, and published by the NMPA. Also, if you are the brand drug manufacturer, you also like if you found like any of the generic have the patent certificate published, you should like file a lawsuit in a court or request the CNIPA to make like this kind of administrative ruling within 45 days once you found the publication. Okay, so on the other hand, let's take a look at for what the generic drug manufacturer should do. So based on the interim measures joint issued by NMPA and CNIPA, the generics must make one of the 4 patent certification. So here the patent certification is the Chinese translation. I think most of you guys also heard it like the generic declaration or non-infringement statement. So anyway, let's just say like if you are generic, you should, once you file this kind of new drug application or a little bit like the US another application with the NMPA, you should have this, patent certification. So there are in total 4 kinds of the patent certification, as I have already shown in the slide: type 1, type 2, type 3, and type 4. So once you have this kind of patent certification, you also need to notify the MA holder. So via email or just send them this kind of information. And then right now for the notification, there is no deadline. So that's why I said like for the branded drug manufacturer, it's better for you to monitoring this platform regularly. Okay, I think yeah, that's basically all for this slide. So right now, in total, it's over 1 year since the Chinese patent law become effective. And then we need to take a look at like how about the current status of the patent linkage system works here in China. So in order to know the current status, we conduct a simple research, and the result is shown in the slide. As you can see, as of recently, I would say in total, more than 1,000 drugs are published in the platforms. So wherein the highest part is the biologic products related patent. And the second one is the traditional Chinese medicine related patent. Actually, it's really interesting, as you can see, the chemical drugs related patent are the least. Also, and if you're looking at the patent certification status, you will find the highest part is the type 1 certification. That is, there is no relevant patent registered on the platform, while the type 3 certification, like I would say for this kind of, I would say for this type 4 certification, you will say 1/3 is no coverage, and the rest, as you can see, the yellow one or the orange one is the yellow one. I would say, the yellow one is like the patent should be invalidated. And all right, so let's come to take a look at the first case here in China. So recently, on April 15th, 2022, actually this year, Beijing IP Court publicly, I would say, pronounced the first instance judgment on the first patent linkage lawsuit here in China. In this case, the plaintiff, actually it's a Japanese pharmaceutical company, Chugai. I would say Chugai is the patentee of the Chinese patent entitled ED71 preparation. And this company is also the MA holder of the brand of a branded drug. So on the other hand, the defendant, Wenzhou Haihe Pharmaceutical, is a generic drug manufacturer that apply for the marketing association. So here, because I would say here after Haihe making this kind of type 4 patent certification, or I would say, or maybe you would say like the type 4 non-infringement statement, Chugai filed opposition for this patent certification to Beijing IP Court. So after the trial, in summary, the Beijing IP Court held that the technical solution used by the generic drug was neither the same nor equivalent to the technical solution of the involved patent, and therefore it did not fall within the scope of the involved patent. So later we will be talking about this case later in our slides. So additionally, as we can say, I would say, as we mentioned before, for this kind of patent linkage, we have this dual track system. So then we come to the administrative ruling case. It's actually basically the same time, the April 25th, CNIPA announced that the first batch of the case was concluded, wherein you can say, as I'm showing in the slide, the applicant is the Purdue Pharmaceutical. So Purdue Pharmaceutical was seeking CNIPA to decide whether the technical solution of the generic drug falling within the 3 patents owned by itself. So according to CNIPA, in total, it took like 5 months for the administrative decision to make. So for us, we will say compare with the court decision, it's really quickly. So also why I would say I will be explaining in the next slide, because we will be talking more about the detail of the civil dispute case. So also according to CNIPA, at the same day, at the April 25th, CNIPA in total received like 59 administrative requests, and 39 cases meet the filing criteria, and right now they are pending. Okay, so here I made this slide because we want to take a deep look at the history of this civil case. So Chudai filed the patent application in 2005. And then I would say 5 years later, the patent was granted with 7 claims, wherein claim 1 is directed to a formulation. So here is an interesting point here. Like since 2020, two other parties, or I would say two other companies, filed the patent invalidation request trying to invalidate this patent. So as you can see, it's basically here. So then you can say in 2020. So it will be say after 15 years since the application, Chugai finally obtained the drug registration certificate from NMPA. Actually, it's what we call the MA. So from the NMPA. So later, like upon, I would say 7 months later. So it's in July 2021, Chugai registered the above mentioned drug in the platform we just mentioned in above slides under the category chemical drug related to related patent. And I would say more specifically, what they register is like the API containing pharmaceutical composition patent. So later, Chugai also, I would say, in this kind of registration, Chugai also specified that the drug related claims are claim 1 to 7. Really interesting. Just 1 month later, the Haihe applied to NMPA for the marketing authorization of the generic drug, and what they made is this type 4 patent certification. And I would say more specifically, it's type 4.2 patent certificate, stating that its generic drug did not fall within the protection scope of the claim 2 of the patent. So it's really interesting. They did not say like their technical solution fallen within the protection scope of claim 1 of Chudai's patent, but they were saying like they did not fall within the protection scope of claim 2 of the Chudai patent. So, but really interesting one, at current stage, many details information relating to this case is not published available. So as I would say, as far as we know, the claim were amended during the invalidation procedure, and actually the technical feature in original claim 2 was incorporated in claim 1 of Chudai's patent. So just based on all the public information available here, so we think Beijing IP Court made the decision based on the amended claims. So right now, what we want to mention, you still remember we were talking about this kind of dual track system. So I would say, as you can say with this timeline, assuming Huaihe notified Chudai immediately, or I would say Chudai found the patent certification after the publication in the platform, Chudai filed the lawsuit with the Beijing IP Court within 45 days and requesting confirmation that whether the generic drug falling within the patent protection. So based on our calculation, it still took like 6 months for the court decision to make. So it's really interesting. Compare with the court, we would say if you try to file this kind of dispute to the CNIPA, actually it's really quickly. Okay, so it's kind of come to the what we should recommend. There is like one thing I always say, William Shakespeare, he said like, to be or not to be, that is the question. So personally speaking, I think that explains the situation for the innovators, or maybe I would say the branded drug manufacturing. So at current stage, we will be recommend following things. The first one, I would say, consider register patent information for all marketed drugs. Actually, it's pretty simple. You can do the registration by yourself, but you can also just entrusting it to us. We will do it for you. And then second, do not forget the time limit. So currently, the registration should be done within 30 days of receiving the drug registration certificate. Later, you also need to update all those kind of information within 30 days of any change. And third one you should pay attention is monitoring the platform regularly, and do not forget the important deadline to the objection. So it's 45 days. And then there is another thing you need to pay attention, like what you should do if you found there is a patent certification, like the type 4 patent certification. You should choose the civil action or like the administrative ruling. Based on our experience, if you want to have like a really fast ruling, we think like the thin IPA is the better choice. But if you are seeking like preliminary injunction, we will be seeing like Beijing IP Court is what you should do. Okay, so the last one, yeah, but also not the least one. So you please be prepared everything in advance. Okay, so we also need to give some suggestion or advice for the generic drug manufacturing. So since I would say, since I'm a big fan of the Stranger Things, I believe the promotion slogan for the Stranger Things season 4 is really suitable for explaining the situation. So I would say before starting the research or the registration process, you should considering the following part. First, maybe you should I would say, I highly recommend you to conduct a patent status check in China for the targeted drug. And second, you should carefully decide the patent certification type. So although this kind of 12 months market exclusivity might be granted for the first generic to invalidate the innovator's patent and receive the marketing authorization, but it's also I would say accompanied by really high risk. So sometimes it may take longer time to obtain the marketing authorization for drug. And the last one, if you try to register, try to have the marketing authorization, do not forget to make the patent certification. It's mandatory. Okay, so basically that's all I want to share today. So thank you for watching, and I really appreciate the time you are spending with us. So I will be turning over the mic to our moderator for the Q&A section. Ms. Yu.
Thank you, Zhenzheng. Thank you for your sharing. It's quite informative and very practical, I think. And now it's Q&A session. Please type in your questions, send them to us. We'll be glad to answer any of your questions. We have a question from Mr. Frank Mayer. Sorry, Mayer. Thank you, Mr. Mayer. The question is, you just mentioned only product patents, manufacturing method, and medical use are eligible for PTE. So then what about the medical devices and equipment?
Also I would say it's like the medical device or the medical equipment. So right now, based on the draft I would say based on all the drafts, the medical device and the medical equipment, they are not eligible for PTE. So the product patent actually means like it's only the drug. So it's only the if like the compound, or maybe it's like the composition, something like that. So yeah.
Thank you. And another question. Thank you, Mr. Collins, Hanks. Okay. And the question is, referring to the formality requirements of PTE, what if the MA holder and the patentee are the same? And in that situation, okay, do we still need to submit the consent letter you mentioned? And okay, and as for the materials showing approved process of manufacturing, is it mandatory?
Okay, so I would say actually this question has two parts. So I will be first answering the first part. So this is regarding to the formality requirements. So the formality requirement right now, the CNIPA, as I said in the presentation, CNIPA will not examine the request; they just receive it. So they say like you should have this kind of consent letter saying like the patentee is allow the MA holder to submit the PTE request. So for us, we tend to believe, or I would say, according to the draft implementing regulation and the draft examination guideline, if the MA holder and the patentees are the same, you do not need to prepare or submit the consent letter. But at the current stage, we had to admit you had to prepare a consent letter saying like, okay, the patentee is allowing the MA holder to submit the PTE request. So Ms. Yu, the second part is the material. So
Okay, I will repeat again. The second part of the question is, as for the materials showing approved process of manufacturing, is this mandatory for the for the PTE?
Oh yeah, so the material showing like that kind of the material showing drug manufacturing process. Actually, it's only it's also, I would say, we need to wait for the finalized implementing regulation and the examination guideline, because like based on the draft based on all those drafts, if the patent is actually what we call like product patent, you don't need to prepare this kind of document. But if the patent is related to a process or related to a method, you need to prepare this kind of document showing like the drug manufacturing process, like approved by NMPA, is related to the method like in the claims. Okay, so do we have like other questions?
Let me see. Okay, good. Here's a question from Mr. Alexandra Hamilton. Thank you, Mr. Hamilton. Thank you for your question. Okay, the question is, okay, the question is, when should the generic notify the MA holder of the non-infringement statement?
Yeah, actually, it's really interesting question. So according to the Chinese patent law and what all those documents we have found, it only says like the generic drug manufacturer should notify the MA holder if they found this kind of patent certification, or what we call, or maybe you can call it non-infringement statement. It only you should, but there is no deadline, as I mentioned in the slide. So you cannot, maybe I would say right now at current stage, at least like 1 month, 2 months, you can decide by yourself. Okay.
Thank you, Zhenzheng. It seems many things are still to be settled here. So I think we're going to close the webinar here. So thank you very much for your interest and the participation. With these webinars, we SPTL is devoted to bring you the latest news, events, and trends of IP practice in China. So thank you for attention. Hope to see you next time. Bye-bye.
Bye-bye.